America had finally a constitution, but there was still a problem. Many states were, in fact, reluctant to ratify it. They feared the new federal government was, in fact, too powerful, and there was no explicit protection for individual rights. So, as the ratification fight raged, the founders, well, they struck a deal. Several states, in fact, agreed to approve the Constitution only after receiving a promise that a Bill of Rights would quickly follow. So, James Madison, as well as his colleagues, they went to work, and out of that effort came the first 10 amendments, the Bill of Rights. And behind each of these rights and amendments is a fascinating story. These are the stories of how America's most important freedoms were born. It's 1787, and Americans have just fought a bloody revolution, partly because the British government tried to silence their newspapers and crush their protests. Well, now this brash young country has written a brand new constitution, but many people are actually furious. I mean, where are the protections for their individual rights? So let's welcome James Madison to the party, a 36-year-old Virginian who initially thought a Bill of Rights wasn't necessary. But his friend Thomas Jefferson, I'm sure you've heard of him, changed his mind with a simple argument from Paris. Jefferson said, "A Bill of Rights is what the people are entitled to against every government on earth." Madison had another motivation too: political survival. He was, in fact, running for Congress against James Monroe. Yes, that Monroe, future President Monroe. And his constituents demanded guaranteed freedoms. So Madison promised to champion a Bill of Rights if elected. And he won by just 336 votes. In the summer of 1789, Madison sifted through nearly 200 proposed amendments from various states. Virginia wanted 20 amendments, and New York wanted 32. Madison crafted his list strategically. He grouped freedom of religion, speech, press, assembly, and petition into a single powerful amendment. And this wasn't accidental. He believed these freedoms formed an interconnected shield against tyranny. And of course, the debates got heated. Some congressmen thought the amendments were completely unnecessary, while others feared they, of course, didn't go far enough. Representative James Jackson of Georgia actually complained that Congress was wasting time on whip syllabub, basically calling the Bill of Rights frothy nonsense. But Madison persisted, even when colleagues dozed off during his long and somewhat boring speeches. And he understood something profound. Democracies need safety valves. Citizens must voice unpopular opinions, practice diverse faiths, and criticize government without fear. The House and Senate wrangled over the wording throughout the fall of 1789. Originally, Madison's First Amendment was actually about congressional apportionment. It failed to pass. What we call the First Amendment today was actually originally third on the list. On December 15th, 1791, Virginia became the 11th state to ratify the Bill of Rights, giving it the 3/4 majority that it needed. The First Amendment became law. Just 45 words, 5 fundamental freedoms, 1 revolutionary idea: that government exists to protect, not suppress, the voices of its people, even the annoying ones, even the unpopular ones, and even the ones that make those in government worry. Our country's founding fathers had fresh memories of British soldiers marching into Boston, confiscating colonist gunpowder and firearms. Those red-coated troops weren't just scary. They represented something the revolutionaries despised: a standing army controlled by a distant government. And here's what Americans don't realize. The founders were actually terrified of professional armies. They'd read their history. Julius Caesar used his army to destroy the Roman Republic. Oliver Cromwell's soldiers crushed English freedoms. Standing armies, they believed, were tools of tyrants. So how do you defend a nation without a standing army? With citizen militias, ordinary people who owned firearms and could assemble when danger threatened. Well, when states submitted their wish lists for a Bill of Rights, several demanded protection for militias and firearms. Pennsylvania's proposal was blunt, and that is, people have a right to bear arms for the defense of themselves and the state. Virginia, Massachusetts, and New Hampshire submitted similar language. But here's where it gets perhaps a little bit more interesting. Madison, well, he faced a challenge. Some states wanted to protect state militias from federal control. Others wanted individual rights to own weapons. Anti-federalists feared the new federal government would disarm state militias, leaving states defenseless against federal tyranny. And Madison thread the needle with his draft. He wrote, "The right of the people to keep and bear arms shall not be infringed. A well-armed and well-regulated militia being the best security of a free country." Did you notice anything? Well, the well-regulated militia part came second. Congress flipped it around, putting the militia clause first. And this small change would fuel centuries of debate. Does well-regulated militia limit the government or explain it? Representative Elbridge Gerry from Massachusetts gave an ominous warning during the debates. What if Congress defined militia as only certain people? Well, this would lead to the violation of every right of freedom. And on December 15, 1791, the amendment became law with its now famous wording, "A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed." 27 words, centuries of interpretation, and probably the most polarizing of all the amendments. But that's another story and another video. The Third Amendment today appears to be, kind of antiquated, probably irrelevant, and absolutely useless. But back in the day, it was a very big deal. Okay, well, let's go back to a time when America did not have the protection of the Constitution. It's the 1760s in America, and life, I guess like now, is complicated. Britain had just fought this massive war, the French and Indian War. Now, well, they've got thousands of soldiers who need a place to stay. So the British government, on their own, of course, decides that your house looks pretty cheap, accommodating, and comfortable. So in 1765, Parliament passes something called the Quartering Act. And this law basically says, hey, colonists, well, you're going to provide barracks, food, and supplies for our troops. Now, at first, it's mostly public buildings, but then comes the year 1774, and that year, everything escalated. Boston had just had its Tea Party, and Britain is furious. So they pass a new Quartering Act that goes even further. So now troops can be housed in private homes, inns, uninhabited buildings, pretty much wherever they want. And soldiers that you did not invite, well, they're eating your food, they're sleeping in your beds, and frankly, they're probably watching your every move. So imagine the violation of privacy. These were not friendly house guests. They were armed representatives of a government that the colonists, frankly, increasingly distrusted. Your home was not anymore your castle. It was basically a military barracks. And this became one of the grievances listed in the Declaration of Independence. Jefferson literally called out King George for quartering large bodies of armed troops among us. So when the founders sat down to write the Bill of Rights in 1789, well, they remembered. They remembered what it felt like to have your home invaded by the government. And they made sure that it would never happen again. And the Third Amendment is actually relatively short and sweet. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. Well, today this amendment seems almost quaint, doesn't it? The government's not trying to house troops in our living room. But maybe that's exactly the point. The founders had a problem, and then they fixed the problem so well that we forgot that it even existed. So the Third Amendment stands most likely really as a quiet guardian of both our homes and ultimately our privacy. So before the Fourth Amendment, Americans and their homes and their belongings could be searched and seized for absolutely no reason. The right to privacy, well, it didn't even really exist prior to the Constitution. Okay, well, let's go back to 1761 because this is an important year, and let's revisit colonial America. You're at home, and suddenly there's a knock at your door. Well, you open the door, and there's a British customs officer holding a piece of paper. And that paper is called a writ of assistance, and it's basically a blank check for tyranny. Well, these writs were a bit of a nightmare, to be honest. They weren't, general warrants, meaning they didn't really specify what the officer was actually looking for or even what they could search for. They could just simply walk into your home, your business, your warehouse, wherever they really wanted, and for whatever reason they wanted. There was no expiration date, and ultimately, no accountability. So back to this year that I speak of, 1761. There was a lawyer by the name of James Otis, and he gave a speech that would honestly echo through history. You see, he challenged these writs in court, calling them the worst instrument of arbitrary power. Well, Otis argued that a person's home is their castle, and the government should not be able to just, barge in without specific cause. Well, like many of us lawyers experience, he lost the case, but he won the argument in the court of public opinion. See, sitting in the court on that day that Otis gave this famous speech, was an important man. That important man was John Adams. He was there. And decades later, he said that speech was the moment the child independence was born. In a letter that he wrote to Mercy Otis Warren, James Otis's daughter, Adams wrote, "American independence was then and there born." Of course, referring to the speech that her father gave many years earlier. Well, this opposition against these writs became yet another rallying cry for the revolution. The Declaration of Independence didn't just complain about taxes. They did complain about taxes, but they complained about other things too. Anyway, it also called out for the king for violating their rights to privacy and security. So when the founders wrote the Bill of Rights, they made sure that the Fourth Amendment would protect this from ever happening again. No more general warrants. And if the government wants to search you or seize your property, well, they need a specific warrant based on probable cause, describing exactly what they're looking for and where. Well, the Fourth Amendment, it says that your home is your castle, essentially. Your papers, your belongings, your person, well, they're protected. The government needs more than just a simple hunch and a power trip to invade your privacy. And yeah, we still argue about what unreasonable means in the age of smartphones and data, AI, and modern and even future technology. But this protection that we argue for, well, it started in colonial homes with British officers at the door and angry colonists saying, no, no, not anymore. Well, if you have watched any cop show or have seen, any of the depositions relating to the Epstein case, well, you have heard the phrase many times, I'm sure, I plead the fifth. But where does this right come from, and why did the founders think it was so important that you could literally refuse to testify against yourself? Well, let's travel back to 17th century England, where you could actually survive the plague, dodge religious persecution, live through a civil war, and a king's beheading, navigate the Great Fire of London, and still die from drinking the water. Yes, that England. Well, anyway, England had a court called the Star Chamber, and it's the stuff of nightmares. There was no jury, there was no due process, and importantly, they could force you to take an oath and answer pretty much any question they ask. King Henry VIII, God rest his soul, well, he loved it, no surprise, and so too did King Charles I, the one that was in fact beheaded back in the 1600s. Refused to cooperate? Well, that's contempt. You're going to prison, maybe even worse. And if you answer honestly, well, you confess to a crime, most likely. Lie under oath? Well, that's perjury. Stay silent? That's contempt. I mean, no matter what you do, you're damned for trying, or damned for not trying. No matter what, you lose. Well, enter into the discussion a guy by the name of John Lilburne, who was a printer back in 1637. So the Star Chamber, well, they haul him in for him allegedly publishing religious pamphlets they did not like. And they order him to take an oath and answer their questions. And Lilburne says no. He refuses. He says no one should be forced to essentially accuse themselves. So what did they do to poor Mr. Lilburne? Well, they threw him in prison. They fined him, and they even whipped him through the streets of London. But our hero Lilburne, he doesn't break. He in fact becomes literally a hero, a symbol of resistance. And his case becomes essentially the foundation for the right against self-incrimination. Yes, in fact, the Fifth Amendment. All right, well, let's flash forward to the American colonies. The founders of this great country, well, they knew this history cold. They read about the Star Chamber, about forced confessions, about governments using their own words as weapons against their own citizens. Some had even, in fact, experienced similar tactics from British authorities. They understood something really important, and that was when the government can force you to testify against yourself, well, justice becomes a bit of a joke. Innocent people can be trapped, coerced, broken. And the truth becomes whatever the interrogator really wants it to be. So they wrote the Fifth Amendment. No person shall be compelled in any criminal case to be a witness against himself. Simple, powerful, revolutionary. But the Fifth isn't just about staying silent. It's also about due process. The government can't deprive you of life, liberty, or property without following proper legal procedures. It protects against also double jeopardy. You can't be tried twice for the same crime. And it also requires grand juries for serious federal crimes. The Fifth Amendment says that the burden of proof is on the government. It's not on you. It's not on us. They, that is the government, they have to prove that you're guilty. You don't have to prove you're innocent. You don't have to give them the rope to hang you with. And for every time we hear, "I plead the Fifth," well, we can thank the British printer John Lilburne for refusing to betray himself in a 17th century courtroom. And it's the idea that your conscience, your words, and your very self, well, it belongs to you, not the government. On March 5th, 1770, British soldiers fired into a crowd of colonists in Boston, killing 5 people. And this became known as the Boston Massacre. And the colonists, well, naturally, they wanted these soldiers hung and quartered. So the accused soldiers, well, they got a trial, of course, but they also got something rather revolutionary and perhaps even unexpected. They got a defense attorney named John Adams. Yes, that John Adams, future president. John Adams. Anyway, Adams wins, and most of his clients, these soldiers, who killed the colonists, well, most of them actually walk free. And, I think it'd be fair to wonder, why would a founding father defend the enemy and such an awful, awful event? Well, the reason he did so, the reason Adams believed in doing this was something, at the time at least, something that was rather radical. Adams believed, that everyone deserved a fair trial, even people we perhaps despise. And this idea would become actually the backbone of the Sixth Amendment. But before we get there, let's rewind even further. You see, the colonists, well, they had watched the British government abuse the legal system for many years. They had already seen people dragged into secret trials, held in jail indefinitely without even knowing the charges against them, denied the right to question their accusers, and so forth. King George's courts sometimes shipped colonists back to England for a trial. I mean, imagine defending yourself miles and miles from home, from your witnesses, from, anyone who could actually help you. Well, the founding fathers, of course, well, they remembered all of this when they wrote the Bill of Rights. James Madison, the amendment's architect, well, he knew that a government could use a rigged justice system to destroy pretty much anyone it wanted. So the Sixth Amendment, well, built a fortress of protections: the right to a speedy and public trial, an impartial jury, the right to know what you're accused of, to confront witnesses against you, to call witnesses for you, and to, of course, have the right to a lawyer. And these weren't just, nice ideas. They were shields against tyranny. the abuse of power. The Founding Fathers had lived, of course, through what actually does happen when government has unchecked power over the accused. They had seen already neighbors disappear, dissidents silenced, and justice twisted into a weapon. So the Sixth Amendment says, not here. Nope, not in America. And today, when you see law and order or hear about, someone lawyering up, well, you're watching these 18th century protections in action. Every time a defendant faces their accuser in court, every time someone gets a public defender, every time a trial happens promptly instead of, many years later. Well, that's the Sixth Amendment working exactly as the founders intended. And as President-to-be, John Adams practiced well before it was cool. Well, back in colonial America, there was a problem. Actually, there were many problems, but in this video, we'll concentrate only on one of them. And it was a problem that the Seventh Amendment tried to fix. So, let's say you're in a business and a British customs officer claimed that you owed him £20 in import duties. Well, money you insisted that you had already paid. Well, in today's world, one party could sue the other, and if there's no resolution, well, the case could be heard in front of a jury of your peers. But this was not always the case, and in fact wasn't the case back in colonial America. In fact, back then, such a dispute would have been held actually before the British Admiralty Court, if I can say that correctly. British Admiralty Court. No jury. Just a judge appointed by the Crown, who, if you lost, then yeah, you probably would have lost. Well, the judge would very likely receive a percentage of whatever was collected from you. Seems fair? No, it was not fair. And this was the very scenario that was common back in the day, and a scenario that terrified America's founders. And it's exactly why they wrote the Seventh Amendment. Now, the amendment itself sounds honestly almost comically simple. And that is, in suits at common law, where the value of controversy shall exceed $20, the right of trial by jury shall be preserved. $20. I mean, today that's, a couple of overpriced lattes and a muffin at Starbucks. But in 1791, for example, $20 was a lot of money. And here's what makes this amendment and this sort of fact pattern rather fascinating. The Seventh Amendment wasn't about criminal trials. The Sixth Amendment already covered those. This was, in fact, about civil disputes, so contracts, property, debts. The founders, they remembered how British officials manipulated civil courts to crush colonial businesses and silence political opponents. A merchant who, for example, criticized the Stamp Act, he might find himself suddenly sued for a massive set of damages in a court with no jury. Well, John Adams himself, the second president, he defended merchants in these courts, and he had watched the system destroy good and innocent people. And when anti-federalists read the new Constitution in 1787, they panicked. Where was the guarantee of civil juries? Patrick Henry, the man who is famous for saying, "Give me liberty or give me death." Well, he thundered in Virginia's ratifying convention and said that without civil juries, the new federal government could become as tyrannical as good old King George. Reality was that a judge could strip you of your property, your business, your livelihood. And James Madison, well, he originally thought that, a civil jury guarantee was unnecessary. Federal courts they'd naturally use juries, he argued, but the anti-federalists, thankfully, they wouldn't budge. States like Virginia and New York, they threatened to reject the Constitution entirely unless civil juries were guaranteed. Well, Madison eventually capitulated, and he included the protection in his draft of the Bill of Rights. Now, the $20 threshold actually sparked, believe it or not, fierce debate. Some wanted it higher, others lower. But they settled on $20 as a compromise. Such is life. Now today that $20 requirement still stands. It was never adjusted for inflation. It's a relic, a fossil from back in 1791, preserved in constitutional amber. But the principle it protects, I think, is vital. When the government or powerful interests drag you into court over money or property, you have the right to be judged by your fellow citizens, not just a single official in a robe who might have been, and likely was, appointed by, for example, the president, and perhaps was politically motivated. And by the way, if you've enjoyed this video, please consider liking the video and subscribing to the channel. Thanks. Well, the story of the birth of the Eighth Amendment is rather incredible, but deeply disturbing. In 1685, Judge George Jeffreys, he had earned the nickname the Hanging Judge by conducting England's bloody assizes, a series of trials where he sentenced over 300 people to death and had 800 more whipped through the streets or sold into slavery. Well, American colonists, they knew about this, and maybe, I'm sure they were, as appalled as much as I am. In fact, many had fled England precisely to escape such judicial savagery. So when they wrote, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted, they weren't crafting, abstract philosophy. They were banning the nightmare scenarios that their grandparents had witnessed back in not so jolly old England. And here's what's remarkable. The Eighth Amendment's language comes word for word from the English Bill of Rights of 1689. So back to why our founding fathers thought it was so necessary to have the Eighth Amendment. You see, British officials turned punishment into political theater in America. In 1765, colonists who protested, for example, the Stamp Act, they faced punishments designed to humiliate and terrorize. Tax collectors had protesters pillared, locked in wooden frames in public squares where crowds pelted them with rotten vegetables and dead animals. Some were branded with hot irons. Others were cropped which is having their ears cut off. I mean, what the absolute The British especially loved excessive fines as political weapons. Can't pay an impossibly high fine for criticizing the governor? No problem. They'd seize your farm, your tools, everything you owned. And the fine wasn't necessarily about money. It was about destroying dissent. And Virginia's George Mason, one of our founding fathers, well, he witnessed these abuses firsthand. When he drafted Virginia's Declaration of Rights in 1776, he included a ban on cruel and unusual punishment. A young James Madison, well, he watched Virginia adopt this protection, and later he insisted that it belonged in the Federal Bill of Rights. And almost nobody debated the Eighth Amendment during the ratification. While they fought over just about everything else, this amendment passed virtually without discussion. Why? Well, because everyone, Federalists and anti-Federalists alike, well, they had seen what had happened when governments turned justice into vengeance. Patrick Henry, the man known for saying, "Give me liberty or give me death," and who opposed, by the way, just about almost everything regarding the new Constitution. Well, he actually praised this protection. He defended clients who had been sentenced to ear cropping for simple petty theft. He knew judges needed limits. And the founders deliberately kept cruel and unusual undefined. They knew society would evolve, and what seemed acceptable in 1791, like public whipping, might horrify future generations. They gave us a principle, not a list, trusting future Americans to recognize cruelty when they saw it. And today, the Eighth Amendment reminds us that a government powerful enough to protect us is powerful enough to destroy us, unless we explicitly tell it where to stop. So, if a right is not written in the Constitution, does it even exist at all? Well, that's what the Ninth Amendment tries to address. James Wilson, one of the most important, but honestly least talked about architects of the U.S. Constitution. By the way, he was also one of the first U.S. Supreme Court justices. Well, he stood before Pennsylvania's ratifying convention in 1787 and delivered a warning that terrified James Madison. Wilson asked, "Why should we list rights at all? In a government of limited powers, the people retain everything not explicitly given away. Start listing rights," Wilson argued, "and some future tyrant will claim that if it's not on the list, well, it doesn't exist at all." That's interesting. I mean, think about the logic for a second. The Constitution doesn't say, for example, that you have a right to grow tomatoes in your backyard. It doesn't mention your right to choose whom to marry, what to eat for breakfast, whether you can learn French or Spanish or hike in the woods. Should we assume that we don't have those rights because they're not written in the Constitution? Well, this argument consumed the founders. Alexander Hamilton, well, he attacked the very idea of a Bill of Rights in Federalist 84. He called it not only unnecessary, but dangerous. Why? Well, because no list could ever be complete. Hamilton warned that any attempt to catalog our rights would accidentally surrender the ones that we forgot to mention. Meanwhile, anti-federalists like George Mason, well, he demanded the opposite. Without a written Bill of Rights, they argued, the new federal government could crush individual liberty. Patrick Henry, well, he in his big voice expressed in Virginia that without explicit protections, federal judges would interpret away just about every freedom that colonists had fought so hard to secure. Madison found himself trapped between two paranoid camps, and both had valid points. If he wrote a Bill of Rights, he risked implying that unlisted rights didn't exist. If he didn't write one, well, states like Virginia and New York would reject the Constitution. That's a problem. So he tried to find a solution. And his solution was brilliantly simple. He'd write a Bill of Rights, but include a catch-all amendment saying, essentially, this list is not complete, and we're well aware of it. And the Ninth Amendment became Madison's escape hatch by declaring that enumerated rights don't deny or disparage others retained by the people. Madison satisfied both camps. Anti-federalists got written guarantees. The Federalists got assurance that the list wasn't exhaustive. But Madison did even more. He, in fact, flipped the burden of proof. Instead of citizens having to prove that they, in fact, possessed a right, the government would have to prove the people had surrendered that right. The Ninth Amendment created a presumption of liberty. Unless the Constitution specifically grants the federal government a power, the people, well, they keep their freedom to act. Roger Sherman of Connecticut, he actually proposed different language that would have limited this protection only to rights expressed in state constitutions. Well, Madison wouldn't have it, and he killed that version. He wanted broader protection for rights that existed, whether any government acknowledged them or not. And here's what makes the Ninth Amendment so radical. It admits the Constitution cannot anticipate every freedom that matters. The founders knew that they could not imagine every right that future generations would need. I mean, they just fought a war because Parliament claimed colonists only had rights that British law explicitly recognized. Well, the Ninth Amendment declares the opposite. Americans possess rights that no document fully captures. And today we argue endlessly about what those enumerated rights include. Privacy, travel, raising your children as you choose. And the founders deliberately did not answer these questions. They simply announced a principle. Just because we didn't write it down doesn't mean it's not yours. The Ninth Amendment stands as the founders' confession of humility and admission that no 18th century convention could possibly catalog every freedom that human dignity requires. In the summer of 1787, Gouverneur Morris of Pennsylvania stood in the Constitutional Convention and proposed something radical. Let's give Congress the power to veto any state law that it doesn't like. Well, the room erupted. Delegates from smaller states nearly walked out. Morris had just triggered the fight that would define American government. And that is, who gets to decide? The states or the federal government. Now, this wasn't theoretical politics. Every delegate in the room well remembered a British Parliament overturning colonial laws at will. Massachusetts would ban cruel debt collection practices, and then Parliament would void it. Virginia would try to help small farmers, and the Crown would override it. And for decades, colonists watched distant politicians crush local democracy. So, when the new Constitution gave Congress massive new powers, alarm bells rang all across America. North Carolina took one look and refused to ratify. Rhode Island wouldn't even call a convention. New York's George Clinton published furious essays warning that this new federal government would devour the states, just as Parliament had devoured colonial assemblies. But the most powerful objection came from Virginia's ratifying convention. George Mason, who, by the way, had authored the Virginia Declaration of Rights, which inspired the U.S. Bill of Rights, stood and asked the question that probably everyone was thinking. Where does the Constitution say what powers the states keep? Where's the line? Because without that line, Mason argued, every federal judge and congressman would naturally expand their own power until states became rather meaningless. And Madison initially resisted adding what would become the 10th Amendment. He thought it was obvious that federal government only had the powers specifically listed in the Constitution. Everything else stayed with the states. Why state the obvious? But then Madison watched the ratification fights turn ugly. And the pattern was clear. Americans would reject the Constitution unless they got explicit protection for state power. Now, what's interesting is that Madison's first draft was actually stronger. He wrote that powers not delegated to the federal government were reserved to the states or to the people respectively. But Roger Sherman of Connecticut, he wanted that weakened. He tried to insert the word expressly, making it powers not expressly delegated, which would have crippled federal authority. Well, Madison fought him off, as he did, keeping the language flexible enough for a functioning government, but clear enough to calm the state's fears. The 10th Amendment became essentially the closing statement of the Bill of Rights, the exclamation point, if you will. It said, the federal government gets these specific powers and nothing more. It was America's insurance policy against recreating the British Empire that they had just escaped. But notice that subtle phrase that Madison insisted on keeping, or to the people. The states don't get everything. Some powers don't belong to either Washington or state capitals, but to individuals themselves. Today we still fight this battle. Every argument about whether Washington or state capitals should decide on an issue traces back to that hot summer in Philadelphia when delegates nearly came to blows over who gets to rule. Now, the 10th Amendment did not resolve the federal versus state tension. It simply acknowledged that it existed. It's essentially the founders' admission that a country as vast and diverse as America. Well, in this country, some decisions belong in Washington and others in state capitals. And many belong to no government at all. So there you go, the incredible stories that came from the creation of our Bill of Rights.